The pain in my wrist was still sharp when I walked into that conference room. 3 days earlier, my car had been rear-ended on the highway, and my right hand was wrapped in a brace, 2 fingers taped together. I hadn't even had time to process the accident because my mother-in-law had called that same evening, telling me there was urgent family business that couldn't wait. I should have known what kind of urgent it was going to be. My name is Claire. I was 31 years old, 7 months out of a marriage that had quietly fallen apart, and I was living in the spare bedroom of a house that had never felt like mine. After the divorce was finalized, I had nowhere immediate to go. My lease had been tied to my ex-husband's apartment. My savings had been drained paying his legal fees. Long story, one I'll get to. My mother-in-law, Patricia, had offered the room herself. She stood in my old kitchen and said, "You're still family to me, Claire. Stay as long as you need." She held my hands when she said it. She looked sincere. I believed her. That was my first mistake, not the last. I want you to understand what my life looked like before everything collapsed. I worked as a financial analyst for a mid-size insurance firm. I was good at my job, genuinely good, the kind of good that gets noticed. My direct supervisor had already told me I was being considered for a senior position. I had a plan. 6 months in, Patricia's spare room, save aggressively, lease my own apartment by spring, and rebuild. Clean, simple, forward-moving. What I didn't know was that while I was making plans, Patricia was making different ones. My ex-husband, Daniel, was Patricia's only son. The divorce had not been his idea. He had made that clear. He had also made clear, in ways I won't detail here, that he didn't handle rejection gracefully. Patricia adored him. She always had. In her world, Daniel could do no wrong, which meant that in her world, I had done all of it. The spare room had been a trap with a welcome mat on it. The conference room that morning was in a building downtown, a family law office that handled estate matters. Patricia had called a meeting between herself, Daniel, her younger brother Gerald, and me. I sat across the table from 3 people I had once considered family, with my bandaged wrist in my lap, not knowing that by the time I left that room, my life was going to be turned completely sideways. Patricia placed a folder on the table and slid it toward me without making eye contact. "We need you to sign these documents," she said. I opened the folder. The first page was a quitclaim deed. My name was on it, and so was an address I recognized immediately, a small rental property my late father-in-law had left to Daniel and me jointly in his will. We had never formally divided it during the divorce proceedings because Daniel had insisted it wasn't worth much. His attorney had argued it was depreciated. My own attorney, whom I could barely afford at that point, had let it slide. I looked up. "This transfers my share of the Maple Street property to Daniel." "It was always his," Patricia said. "His father meant it for him." "Patricia, my name is on the deed. It's been on the deed for 4 years. Daniel leaned back in his chair. He had the look on his face that I had seen 100 times during our marriage, the practiced calm of someone who knows he's already won. "You're living in my mother's house," he said. "You're eating her food. You don't pay rent. The least you can do is stop holding on to something that was never really yours." Gerald said nothing. He just watched me with flat eyes. I closed the folder. "I'm not signing this today." That's when Patricia's voice changed. Not loud, not screaming. Something quieter and more deliberate, which was somehow worse. "Then you'll need to find somewhere else to sleep tonight." I looked at her. I thought about my clothes in that spare bedroom. My laptop. The box of documents I kept under the bed, including my own financial records, my insurance paperwork, copies of my employment contracts. "You can't do that," I said. "I've been living there for 4 months. I have tenant rights under state law regardless of whether I pay rent." Gerald made a small sound that might have been a laugh. "Try explaining that to a judge," Daniel said, "while you're couch surfing." I picked up the folder, put it in my bag, and stood up. My wrist throbbed. I was wearing a work blazer and low heels, and I felt, in that moment, like the floor had dropped 6 inches beneath me, but I kept my face still. "I'll have an attorney review this," I said. "You have 48 hours, Patricia said. "After that, your things will be on the porch." I walked out. I want to explain why I didn't call the police that day, because I know that's the first question. I had tried that road before. 3 months into living at Patricia's house, Daniel had come over uninvited twice, once to pick up some things he claimed to have left, once at midnight to bang on the spare room door demanding I talk to him. Both times I had called the non-emergency line. Both times the responding officer had treated it like a domestic spat, had spoken to Daniel like an old friend, and had left without doing anything. I found out later that Daniel had been a volunteer at the same precinct's community outreach program for years. He knew people. I was nobody to them. I had learned, the hard way, that calling the police was not always the first move available to me. What I did instead was smarter. I went to work that day. I sat at my desk and did my job because I needed that paycheck, and I needed my supervisor to see me as stable and reliable. At lunch, I called a tenant rights hotline and spoke to a paralegal for 20 minutes, who confirmed what I already suspected. Patricia could not legally remove me with less than proper written notice, regardless of the informal arrangement, and any attempt to do so while threatening me with a document signing constituted potential coercion. I wrote all of that down. After work, I went to the public library instead of back to the house. I needed to think somewhere quiet where no one could walk in on me. I sat at a corner table and opened the folder again. And that's when I actually read it. Not just the quitclaim deed on top, but every page underneath it. There were 6 documents in total. The deed was the first. The second was an amendment to my late father-in-law's original estate filing. I stared at it for a long time. Robert Daniel's father had died 2 years before our divorce. I had attended his funeral. I had liked him, actually. He was a quiet man who grew tomatoes in his backyard and always asked me about my work with genuine interest. His original will, which I had seen during the divorce proceedings, had left the Maple Street property to Daniel and me jointly and had divided his financial accounts between Daniel and a charitable trust he had established for a local children's hospital. The amendment in this folder changed those instructions. It was dated 4 months before Robert's death. It removed the charitable trust entirely and redirected those funds, approximately $340,000, into a private account under Patricia and Gerald's joint names. I sat very still. Then I read it again. I thought about what I knew professionally. I had spent 6 years analyzing insurance documents and financial filings. I knew what legitimately amended estate documents looked like. I knew the formatting, the language, the witness requirements. I knew which notary stamps were standard in this state and which weren't. This document had a notary stamp that didn't match any registered seal format I recognized. I took photos of every page with my phone. Then I went back to the house, smiled at Patricia in the kitchen, ate the dinner she had made, and went to my room. I sat on the edge of the bed and thought very carefully about what to do next and in what order. The next morning, I called in a half day of remote work and drove to the county probate court. I asked to see the public record of Robert's estate filing. It took about 40 minutes for the clerk to pull it. The amendment in Patricia's folder was not in the public record. There was an amendment on file, but it was dated 8 months before Robert's death, not 4, and it made much smaller changes to some personal property distributions. Nothing that touched the charitable trust. Nothing that redirected $340,000. The document Patricia had handed me was not the legal amendment. It was a fabrication. I drove to my car and sat in the parking lot for a while. I wasn't panicking. I want to be honest about that. I wasn't panicking. I was calculating. There is a difference. When you have spent years working in financial analysis, you learn to treat information as data before you treat it as emotion. I would have time for emotion later. Right now, I needed to understand the full shape of what had happened. I went back to work and spent 2 evenings doing what I did best. I pulled every document I could access through legitimate means: public probate records, property records, business filings. Patricia and Gerald had a small real estate holding company together. It had been registered 3 years ago, about a year before Robert died. The Maple Street property I was being pressured to sign away had been quietly transferred into that company's name 6 months after Robert's death, except that it couldn't have been legally because my name was still on the original deed and no one had ever gotten my signature, which meant they had either forged my signature or filed a fraudulent transfer. I went back to the county recorder's office. I asked to see the transfer document. My signature was on it, a version of my signature I had never written. I sat in my car again. The wrist brace was still on. Outside the window, people were walking dogs and carrying groceries and living ordinary lives, and inside that car I was holding the edges of something enormous and trying to decide whether to let go or hold tighter. I held tighter. I had a coworker, a woman named Donna, who worked in our firm's fraud investigation department and who I had eaten lunch with probably 100 times over the years. I trusted her judgment completely. I called her that evening and asked if she could look at some documents with me informally, off the clock, without me telling her the full context yet. She said yes, without hesitating. We met at a coffee shop 2 days later. I spread the photocopies across the table. Donna looked at everything carefully. She didn't say anything for a long time. Then she said, "Claire, this notary stamp is from a provider that lost its state certification in 2019. You can look it up. It's public record." She also pointed out 3 other irregularities I had suspected but hadn't been able to name precisely. The font on the amendment didn't match the standard template used by the estate attorney on record. 2 of the witness signatures appeared to be the same handwriting in different pen pressure, and the document's formatting had a header inconsistency that suggested it had been assembled from pieces of other documents. "This is fraud," Donna said. Not dramatically, just flatly, the way professionals say things. "I know," I said. "What are you going to do?" I had already made my list. I want to pause here because I know what some people would say at this point. Why didn't I just go to the police immediately? I had evidence. I had photocopies. I should have walked into a station and handed it all over. Here's what I understood that I didn't understand before. Fraud investigations, especially estate fraud, are not simple police matters. They involve probate court, potentially the state attorney general's office, forensic document examination, and in many cases a civil attorney who files a separate action. If I had walked into a police station with photocopies from my phone, I would have been handed a pamphlet and told to consult a lawyer. I had seen it happen to someone else. I needed the evidence properly gathered and the complaint filed through the right channels by someone who knew those channels. So I found an attorney. Her name was Margaret. She was a referral from the tenant rights paralegal I'd spoken to earlier, and she specialized in estate litigation and fraud. I met with her on a Thursday evening, laid everything out in the order I had assembled it, and didn't leave her office for 2 hours. Margaret listened to all of it without interruption. Then she said, "You're going to need original documents, not just photos, wherever you can get them. And you're going to need to stop living in that house as soon as you can safely do so without tipping them off." She also told me something that changed the way I understood the whole situation. The $340,000 that had been redirected from the charitable trust had likely triggered a separate issue. The children's hospital that Robert had designated as beneficiary was a registered nonprofit, and the amendment that diverted funds away from them may have implicated federal nonprofit protection statutes. Margaret had connections in the state AG's office. This could be bigger than a family fraud complaint. I went back to Patricia's house, and I kept my face completely normal for 11 more days. That is harder than it sounds. Dinner every night. "How was work, Claire?" "Fine, thank you." Watching Daniel come by twice, watching Patricia and Gerald have long phone calls behind the closed kitchen door, watching all of it and saying nothing. My wrist healed. I packed my things gradually, a bag at a time, storing them at Donna's apartment. I made copies of everything in that house that was mine, documents, records, anything with my name on it. On the 12th day, Margaret filed a formal fraud complaint with the probate court and submitted a concurrent referral to the state AG's office regarding the charitable trust diversion. She also sent a formal cease and desist to Patricia's address regarding the coercion attempt tied to the quitclaim signing. That was a Tuesday. On Wednesday morning, I moved the last of my things to Donna's apartment before Patricia woke up. I left my key on the kitchen counter. I did not leave a note. Patricia called me 4 times that day. I let every call go to voicemail. Gerald called once, Daniel called 6 times, and then sent a text that said, "You have no idea what you've done." I did not respond to any of them. What followed was not fast. I want to be honest about that too, because I think people expect revenge to come quickly and cleanly, like a door slamming shut. It doesn't work that way. It took 4 months. During those 4 months, I stayed at Donna's, paid her a fair amount for the room, and kept going to work every day. I got the senior analyst promotion in month 2, my supervisor said. My performance had been remarkably consistent even under what she somehow sensed had been a difficult personal period. I didn't tell her the details. I just said thank you and meant it. Margaret worked steadily. The probate court opened a formal review of Robert's estate based on the fraudulent amendment. A forensic document examiner confirmed that the notary stamp was invalid and that the amendment had been produced using a combination of scanned elements from legitimate documents, essentially cut and pasted into a new forgery. The 2 witness signatures were confirmed to be from the same person, Gerald, as it turned out. He had signed twice, using slight variations of his handwriting, apparently believing no one would compare them carefully. The fraudulent property transfer, using my forged signature, was filed as a separate complaint with the county recorder's office and referred to the district attorney. The charitable trust diversion attracted the most serious attention. The Children's Hospital, once notified, retained their own legal counsel and joined the complaint. $340,000 redirected from a registered nonprofit beneficiary was not something the AG's office set aside easily. I was not in the room when any of the legal actions came to their conclusion. I had given my statements, submitted my documentation, and stepped back. Margaret kept me informed. Patricia's attorney negotiated a plea on the estate fraud. She and Gerald were required to return the full $340,000 to the charitable trust plus interest, surrender the fraudulent property transfer, and accept 5 years of formal probation with financial oversight. The Children's Hospital received what Robert had intended for them. The forged signature on the property transfer was filed as a separate criminal matter. It was still being processed through the DA's office when I moved into my own apartment. Daniel was not charged with anything. There was no direct evidence that he had known about the forgery specifically, or at least none that could be proven. He knew I knew that. He texted me once more, about 6 weeks after everything became public, and said, "I hope you're happy." I thought about a lot of answers to that. I settled on not replying at all. The Maple Street property remained in my name, my legitimate, original, unforged name on the deed, and was subsequently handled through the original divorce settlement terms that should have been applied in the first place. I received a fair buyout. I used part of that money to lease my own apartment. It's a 1-bedroom on the 4th floor of a building I chose entirely by myself, based on nothing but my own preferences. There's a window in the kitchen that gets morning light. I keep a small plant on the sill. The first night I slept there, I left the window cracked open and lay in the dark for a long time listening to the sounds of my own street. I cried a little, not from sadness exactly, but from the particular exhaustion of having held everything tightly for so long and finally being somewhere I could let go. My wrist had long since healed. There was no brace, no tape, no reminder of that conference room and that folder sliding across the table toward me. I think about Patricia sometimes, not with hatred, which surprised me, more with a kind of tired clarity. She chose to protect her son so completely that she stopped being able to see anything else what was right, what was real, what she was becoming in the process of covering for him. I think people can love someone so much that the love itself becomes a kind of damage. That's what I saw in her. It didn't excuse what she did. It just explained a shape of it. Gerald, I think about less. He was the one who held the pen. I think about Robert the most, maybe. A quiet man who grew tomatoes and asked about my work and made a careful plan for what he left behind, a plan that included a children's hospital because he believed in leaving things better than he found them. The money he set aside eventually got there. It just took a detour through the worst version of his family before it arrived. I hope the hospital did something good with it. I think he would have wanted that more than anything else. What I know now, that I didn't know when I was sleeping in that spare bedroom and eating Patricia's dinners and making careful small talk, is that I was already stronger than the situation. I just hadn't proven it to myself yet. The proving took 11 days of held breath and 4 months of paperwork and more cups of bad coffee in attorney waiting rooms than I care to count. But the strength was already there before any of it started. It was there when I closed the folder and didn't sign. It was there when I drove to the probate court on a half day of remote work with a bandaged wrist and asked a clerk to pull a public record. It was there every night I sat at the dinner table and said, "Fine, thank you," and gave nothing away. I think about that woman sometimes, the one who sat in that conference room with tape on her fingers and a brace on her wrist, and 3 people across the table who had already decided she was beaten. I want to tell her what I know now. I want to tell her that the documents in that folder were the first mistake her opponents made, not the last, and that people who build their security on forged signatures are building on sand. She didn't need to hear it then. She already knew it. She just kept going anyway. That morning light is coming through the kitchen window right now. The plant is doing well. I made coffee and I have work in an hour, work that I'm good at, work that I chose, work that no one can threaten to take from me by sliding a folder across a table. Some mornings that's everything. Some mornings everything is enough.